Okay, morning, everybody. My name is Dave Lynch. I'm the town manager. We are convening the second meeting of the negotiation session between the new FOP bargaining unit for the Pembroke Park Police Department with their negotiating team and with the negotiating team of our municipality, also joined by administrative representatives from our police department. The public is watching this thing, so I think for the purposes of what they're doing, since I don't think we're gonna have chyrons or lower thirds, so they know who's speaking, I'm gonna ask everybody to go around the table and sort of introduce themselves, and we'll begin with Sergeant Dodge.
Sergeant Brian Dodge, Pembroke Park Police.
Hold on a minute, let's make sure we're getting some good audio. Is that mic gonna pick up the representatives of the bargaining unit?
Sergeant Brian Dodge, Pembroke Park Police.
Paul Miniotis, FOP.
Channel Williamson, Town of Pembroke Park.
Lorena Bravo from Bryant Miller Olive, outside counsel.
I'm Denise Heekin from Bryant Miller Olive, outside Labor Council to the town.
Great, I already introduced myself, Town Manager Dave Lynch.
Danny Horsey, Police Chief.
Deputy Chief Jason Ochoa.
Before we get started, this is gonna be awkward passing around a microphone, Susie. I don't know if we're gonna get picked up. Okay, let me just
These are
ask,
very sensitive.
yeah, maybe, okay, everybody project when you talk, don't be timid. No, I mean that,
Yeah.
because the public needs to know what's going on, and we're not fulfilling our transparency duties if we are doing a broadcast which does not officially pick up the audio, so. Well, without any further delay, I think what we're gonna do is, we have some representatives, as you know, from our law firm, and we're gonna have them sort of initiate the discussion. So Denise, you wanna begin?
Actually, Lorena's going to begin.
Okay. Lorena, do you wanna begin?
Sure. Thank you for the introduction, David. You've also met Denise. Denise is a new member to the team, so Denise will be participating in future negotiations. So the last meeting we had was on October 29th, and we discussed 17 articles. We reached agreement on 5, and the town made counter proposals to the union's proposal on 12 articles. Have you had an opportunity to consider those articles? Is there a response to those articles?
Let's go over them.
Yeah.
Sure.
And you have them down there, right?
I do. I did not bring hard copies for everyone, but I can go through the ones we kept and like.
I think we're equipped with hard copies, so if you
You
make
guys have-
reference by article number.
Sure, I have everything digitally, so.
Great.
Okay. Okay, so Article 1, we accept the town strike through Section 3. So, if,
So Article
Okay.
number 1, right?
yeah.
Does that mean we've reached agreement on one?
Yes, ma'am.
Yeah.
Okay. I don't wanna overstep.
I know what this.
You did, okay. And then we'll move on to Article 3, which is no strike or lockout. Section 1, the town proposed the addition of, I guess it's the right to seek and obtain legal or equitable relief. We can agree to that, we accept that. And then in Section 2, you guys struck out the language there and just added it from the statute, and so we accept that. And I don't believe there were any additional changes, so we can agree on that article.
Only the insertion of the references in section 6, those were blank in the union's proposal, but we inserted the proper reference, which may change once we
Okay, so
create it.
I guess we
Right.
can tentatively accept it.
Yeah. That's.
Yeah, the numbers and stuff may all change, so.
Right.
And then the next one was Article 10, Equal Employment Opportunity Affirmative Action. In Section 1, the town struck out the last 2 lines. We reject the strike here. Section 2, and correct me if I'm wrong on anything, but section,
I'm sorry, could you review that, what you just said about,
Rejecting member.
yeah, so section
Public
1, the
Mhm.
town proposed and to, striking out and to assure all personnel programs, policies, and assignments are free from unlawful discriminatory practices.
do
We,
you want,
we reject that.
So I think they reject our proposed
We-
strikeout.
Exactly,
Yes.
sorry.
oh, so you want to keep that language?
Yes, sir.
Okay,
And I mean, everything's subject to
yep, right.
negotiating. I just- These are what we're. Okay, and then section 2, the town struck out within the department. I think that's just for clarity, so we accept that. And then section 3, the town included or the union in relation to, we accept that. And then section 3.1, the town added the last sentence, and we accept it except for we want to strike out without limitation or expansion. So the language would just be, this section will be administered according to applicable federal, state, and local law.
In section 3, there was also a strikeout of present in the second to last line.
We're good with that, yeah. And then section 5, the town struck, the union shall be included in the negotiation of any future consent decrees which affect the union and its members. We reject that strikeout, we would like to keep that language.
Should we discuss these as we go through them? What do you recommend?
I think we let them respond and then we
Okay.
determine whether we should
Okay.
caucus over anything
Okay.
that's being discussed.
Right.
Well, if we've got a question, I'll ask it, and I was gonna ask it about this. What, I guess you guys originally proposed this? But what
Which
kind of
one?
consent decrees are you talking about for section 5? Talking about like the Department of Justice comes in and does a consent decree and.
Quite frankly, I'm not sure.
I don't-
We just wanna
okay, we
be,
could-
we
I
just
mean-
wanna be included if something were to change in policy, it should, I think the union should be included in that,
That's all.
yeah.
Okay, all right.
I mean, we can also talk about how to change that language, you know. We just wanna be able to be included if there's any policy changes that the town wants to implement.
Okay, so.
Included
we
in,
can
in
do that.
discussion.
Yeah, in
Yeah.
discussion, yeah.
Okay,
Obviously, you guys have a right to make the policies, but
Of
we
course.
just like to be involved in it, and maybe, you know.
yeah, I mean, consent decree just has a kind of a term of art in the legal world, you know, and back in the 80s, there used to be a ton of consent decrees, right, with the Department of Justice and stuff.
We can fix the language.
But we can, okay,
Yeah.
all right.
Maybe if it's something you guys wanna come up with, something that we,
Well, yeah, we'll think about it, yeah, okay.
that's fine.
And then Article 10, we're still in Article 10, Section 6. You guys struck that out and we accept that. Moving on to Article 11.
Does that mean everything in between is been accepted?
I'm going through each article that we held.
Right.
So, yeah.
Wasn't there Article 7? Or,
Right, I think the answer to the question we just got was anything between, up until 11 was otherwise okay, right?
I don't remember discussing 7.
No, I don't either.
We did discuss
Oh.
7, the union had, some corrections to make to 7, the hours for union business needed to be
Increased, yeah.
corrected. And also there was a request, to allow certain access to the members or new hires, maybe during roll call at some point, in order to instruct them over their membership.
Right.
But I think we left the meeting, last time where the union was going to propose the, language with respect to the limited, solicitation, for lack of a better word, on the last page of Article 7, which would be Section 2, letter I.
Okay.
So I'm understanding that, unless we TA'd the article at the last meeting, and if they don't raise it here, then it's something that's still left to be discussed.
Okay, I didn't mean to interrupt your flow.
No, that's fine. Article 7, I missed that one, so while you guys are
Okay.
caucusing, we'll
Yeah,
discuss
we'll
it.
go over it.
Yeah.
Okay,
If
Okay.
you choose
Sure.
to caucus. I apologize.
No, that's all right.
Back to 11.
Okay, so Article 11, rights of law enforcement officers while under investigation.
Held that, yeah.
Yeah, we held this one. Okay, so we would accept, the town struck out under the following conditions, so we accept that. And then the town included in accordance with Florida statute, chapter 112, part 6, referred to as the Law Enforcement and Correctional Officers Bill of Rights as amended from time to time. We accept that, but we would like to add, should the statute be amended during the term of this agreement, such amendment shall automatically be incorporated herein. And then we would strike the rest of that sentence from this to the end Florida statutes, and then accept striking out the rest of the statute, if that makes sense. And I can forward all of this so that you guys have it.
Do you have any questions with what she just said? or-
Yeah, are you following?
I do. If we agree to that language that you're talking about, does that mean you agree to the rest of the strikeouts that we have through letter
Yes.
L?
Yes.
Okay, great.
And I don't think there was anything else that the town countered.
Let me just make sure I understand. So, you're okay with, in accordance with Florida statutes, chapter 112, part 6, referred to as Law Enforcement Correctional Officers Bill of Rights, has amended from time to time.
And then, should the statute be amended during the term of this agreement, such amendment shall automatically be incorporated herein.
Okay. Okay, should the statute.
We just
I
want it
think
to
that's,
be
yeah, I think
super
that's the
clear.
same as it has amended from time to time, but
If
that's,
I mean, that's fine. If you
Okay.
wanna remove as amended from time to time, and then just add in our language, that might be
we
more
can work
clear.
with that. And then this reference to part 6 in chapter 112 Florida statutes is information, you want that sentence is okay, or you want
We
that out?
strike that.
Okay.
That's our counter to
Our proposed
Your-
last sentence
yes.
is strict,
Okay.
that's your counter.
it. Sorry, I'm getting used to the language.
Yeah, that's okay.
So the rest of our strikeouts are okay, and the rest of the language that's proposed for that particular article is okay also, right?
We had anything?
Yeah, we didn't.
Okay, great.
The next one we had was Article 15.
I had 12. 12. Subcontracting, we had that held. You missed that one?
Yeah.
Okay, we'll come back on that one.
Okay, so can we hold 12?
Yeah, hold out, let's go to the next one.
I presume if you jump to another article over that, everything in between is held then,
Right.
right? Okay.
Yeah,
We'll come back.
that'll be fine.
The next one, then?
Article 15, discipline and discharge.
Yes.
Okay, so this one, I believe you guys wanted some language, or we should have proposed some language for progressive discipline, so we have that. Okay, so section 1, the town included the right to take disciplinary action belongs to and remains with the town. We accept that. We would just like to add in accordance with Article 5. And then the next sentence, the provisions of this article shall supersede any previously existing grievance procedures, whether provided by rule, policy, or practice. We strike that. I believe the town wanted to add that in, so we should reject that, I should say. And then, just for clarity, we propose adding in a section 1.2, which would outline the progressive discipline language, and again, I can forward this to you guys so you have it, but it says the town follows a system of progressive discipline in that the town imposes a level of discipline necessary to correct undesirable behavior. Actions taken may increase in severity if the original offense is not corrected or if a subsequent offense arises. Progressive discipline assures that discipline is administered consistently and in a non-discriminatory manner. And then I would propose section 1.3, disciplinary actions are as follows, and then it includes 1 through 4, which was written reprimand, suspension, demotion, discharge. I know that's a lot, but, okay. And then section 2, we reject. Sorry, I'm just trying to read my notes. Okay, so I think you guys wanted to add that a notice of improvement action plan may be used to memorialize deficiencies, and we reject that. Basically, we want to keep what section 2 originally was.
Can I ask why you want to reject a improvement action plan?
Sure.
Just,
Yeah, a PIP isn't a form of discipline, so I don't think that it should be included in the discipline or discharge. To be quite frank, in our experience, I had a police officer in Venice Beach that was placed on a performance improvement plan, and then the city over there used that PIP to open an investigation into him. So they basically violated 112. That was our argument, at least, and the arbitrator bought it, and we got him his job back. So we just don't want a PIP to be included in this because it could, I'm not saying that it would happen, but it could lead to an investigation, which basically if you start a PIP, it's starting an investigation from the back and working your way up.
So you're completely opposed to any PIPs, or are you okay with the PIP properly used?
oh, there's nothing wrong with that, it's just
Yeah.
not as far as, discipline.
And not, okay, so it's someplace else and
Oh,
properly
absolutely.
used.
Yeah, there's a need for that.
Yeah,
Absolutely.
that's fine, and we just don't want it as part of discipline and discharge.
Sorry, where would you recommend that be?
When, what, to use it?
Where would you recommend it in this agreement that should be?
I mean, that should be part of y'all's evaluation process, maybe of the officers. That, I think, is a management right. I mean,
Yeah.
but
I mean, isn't a PIP designed for ongoing training and development throughout someone's tenure, so where would it fall?
Well, you're
But that
right.
may not be a disciplinary matter. I don't
Exactly,
think
it's
what they're
training,
getting at.
Yeah.
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 Right, okay.
If it's performance evaluations or something, we'll take a
Oh,
look
okay.
at it.
yeah.
Okay.
We're totally okay with it being training, but
Right.
for disciplinary purposes, I don't know.
And that's pretty standard, the way they do it.
Yeah.
Understood.
Okay.
Okay, so down to section 4.
You okay with section 3?
Yes, we're good with
Okay.
section 3. And then section town counter proposed that a written reprimand may not be, appealed or subject to arbitration, and we reject that as well. Since a written reprimand is technically a form of discipline, we want to be able to fight it if we have to.
Let me bring that up real quick. The written reprimand, as of right now, is not a form of discipline, is that correct? For this town, right. So we'd have to, address that then. If it's not part of the discipline process, we're gonna put it in, or we're not gonna put it in?
Well, you're proposing to put it in, right, based on your amendment to section 1.2.
Right.
What I would inquire with you is up to what level do you intend to grieve a written reprimand? I mean, it's uniform that written reprimands get taken up to the chief and you have the
Yeah.
opportunity to rebut, and
Right.
that's the end
And
of
I'm
the
good with
story.
that. Yeah, we're good with that.
And they go away after, what, a year or two, whatever the,
Yeah, the
Yeah.
first language we have, yeah.
It's,
Yeah.
so,
We're good with that.
Sounds like we agree.
right.
So we'll just
So
have to
it's
massage
just-
the language.
yeah.
Okay, we'll review it again for that concept.
All right.
And section 5.1, you guys added I think it's just for clarity, the right to, and you struck out considered, we accept that. And then section
5.2.
5.2 revolves the pre-D hearing with the chief. The town struck out an audio recording of the hearing shall be made. We reject that. We would want an audio recording of that.
That's just a lot of public record and it's an administrative, burden on the town. Every record we create needs to be kept and maintained according to retention schedule.
I mean, it's part of the discipline, so discipline is public knowledge.
No, I understand, but you're talking about a different medium, right? Now you're talking about not only the documents created, but now you're also talking about an audio recording also needs to be created.
And an internal meeting like that is not public. That's a private meeting between the department and the union and the individual, who's subject to possible disciplinary action.
A pre-D hearing?
Yeah, those are
I
not
don't
public,
agree with that.
but they're not public. They absolutely are not
Well, we
public.
can bargain and we can negotiate, but in many other agencies, they're all audio recorded,
I
and
don't
we
have
have that
one.
for arbitration.
I don't have one agency where there's audio recorded. I'll just
What
let you
am I
know that.
missing here? Are we,
First, Paul, I'm sorry, there's two distinct concepts. One is whether the meeting is public and the other is whether the record created is a public record. So, what Denise, I think, is trying to say, and I agree with, is the meeting is not public. I mean, general members of the public can attend, you don't need a notice, you don't need minutes, Now, the records themselves, generally
Oh,
are
that was,
public,
well, that's
right?
part of the, yeah, it's a
So
public
all we're
document
saying
if you
is
create it.
the documentation as a result of that grievance step
speaks
is
for
a public
themselves?
record, right, and would, right, and
Right.
it's going to reflect what the town's response is gonna
I want
be.
to see where,
I apologize, I think I misunderstood you.
Okay.
I understand that the pre-D is not a public meeting, I do
Okay.
understand that, however, the audio recording is public, and whatever documents were
Right.
created. Yeah, and so
We
I
agree.
think the union should be entitled, and we understand that the member would be there plus a union representative, but usually the attorneys are not involved in
Right.
that, and so I would like, and me or whoever comes after me would like an opportunity to hear what happened, so.
By the
I
way,
mean, I'm not,
Yeah.
there's some benefit to that. There's some detriment on both sides. If I were a member of the union, because once that recording's created, that's it. It's a permanent record, and anybody from Channel 10 can, well, they're probably paying
And
attention
let me
right now,
just,
can come
Yeah.
get a copy of it. I'm not sure if I'm ever in the union, I want that to happen.
Besides, you're gonna have to keep it.
Well,
I mean, this is not the hill I die on.
That's
So
not
I
the,
don't-
Right.
I don't,
the
Well,
toughest part of it.
and here's something else to think
You
about,
guys are
Ron.
chief
he
negotiator,
doesn't have an issue with it.
so you wanna strike it?
And-
I'm okay with that.
This is not the
Okay.
hill we die on.
Okay, yeah, I wouldn't think so.
All right,
Yeah,
great.
strike
Okay.
it.
All right, let's keep moving.
Your president said strike it.
Yeah.
Okay.
Okay, 5.3. We accept the town's, counters, so I think you guys struck out be considered, so we accept that. And then you struck out desire for and added to right to, I think that's fine with us. Section 5.4, the town included, or excuse me, they struck out there, which is for clarity, that's fine. And then the town included within reasonable time, not less than 10 days. We would reject that just because we think it needs to be, there needs to be a time frame. And I mean, we can negotiate what time frame. I just left 10 days, but if you guys think you need a little more time, that's up to y'all, but. Because reasonable is subject to interpretation.
Can I get you to go back to 5.3 for a minute?
Sure.
If you agree to those strikeouts, I'm not sure it reads like an English sentence. Failure of the employee of the union to appear at such scheduled hearing shall, except for mutually agreed upon reason, waiver of the right to a hearing.
Be a waiver.
Should
Be-
be,
Be a
Yeah.
waiver.
right, because you struck out B, so
That was our
we're
problem.
putting,
That was us.
right.
I was accepting y'all's language.
Yeah.
So,
Right, I mean,
yeah,
but-
yeah.
We'll make it grammatically correct.
Yeah.
Okay, sorry, that's an English major.
I'm grammar right now.
Insurance.
so that
At
sounds
the,
like-
no, at the end, I'm sure we'll go through everything and,
yeah,
you know.
There'll
It's a
be-
$5 deduction for every syntax error.
Uh-oh, I'm in trouble.
I know. It's hard when you have so many, you know, articles. Okay.
Yep,
I don't remember where I was.
so we were at 5.4.
Okay, so yeah, we believe that the time frame needs to be
Okay, yeah.
Define.
stated,
So you just
defined.
wanted the police chief, or designee within 10 working days following the close of the hearing will submit.
Yeah.
Okay.
And then the town included in considering the imposition, and we accept that inclusion. And then in the next sentence, the town struck there, we accept that. And then the last sentence, the town added, and the totality of the circumstances, we would reject that inclusion. Reject that. Counter. Yeah, 5.5, it's just the same thing as I said before, the days need to be defined, so we would strike or reject the reasonable time.
Keep moving.
Oh, okay. I'm
likes
trying to
us.
let people write.
Sorry.
Yeah,
It's
we're good.
okay. Okay, section 6, you guys struck regular, we're fine with that. And then section 7, the town struck by the proper authorities, we agree to that. And the town included in the next line, the commission of a felony or a crime, we accept that. And in section 7, this was our oversight, but we want to remove such leave shall not be subject to review through the grievance arbitration process set forth in this agreement. So, and I can explain why you would like me to. But we're basically reproposing section 7.
So you want to be able to grieve it.
Yes, we would like to be able to grieve if someone's placed on admin leave without pay for
So we
a
grieve,
crime.
we grieve that, and then if they, after the outcome of the crime, if there's discipline, there's a second grievance
Yes, ma'am,
procedure.
yeah. And if you like some background, we had a case in Hollywood where the officer was placed on admin leave without pay, and he was charged with misdemeanor battery. It was right before COVID. So his court date didn't come until 4 years later, and he had been on admin leave without pay. And he was exonerated, unfounded, in front of a jury. And then once we get to arbitration, he's only subject to back pay until he was officially disciplined, which was 2 years after he was placed on admin leave without pay. So he lost 2 years of back pay.
You get it back?
He did not. The arbitrator, we had a second arbitration, or excuse me, we submitted briefs to the arbitrator, and the arbitrator found that because the admin leave without pay was adverse to him, and we didn't grieve it in the 10 days that it was required, he did not get back pay.
That's why we grieve everything now.
So now we
Anything.
just
Yeah.
grieve it.
We grieve.
Yeah.
To
So
hold
would
it.
you be opposed to perhaps combining those two processes? So like after the criminal charges were over with, you could also grieve the person being placed on administrative leave without pay? As opposed to doing, because here's what will happen, somebody's up on criminal charges, right? They're out on administrative leave with pay, you
With
get
pay or
to-
without pay?
without pay.
Yeah.
You guys get to go ahead and grieve that.
Mhm.
Well, what if he's still he or she is under criminal charges when that arbitration hearing comes up? Your guy's not gonna testify.
Typically, we would hold the.
Everything would be in a band.
Okay,
Yeah,
so
we
we
would
could
hold
put it all
discipline.
together as one at a point later. You're not demanding the ability to grieve the administrative leave without pay as soon as it's implemented.
Well, we're only
You could-
doing, we're only grieving it right off the bat to
To
Put it on
comply
record.
with the 10 days.
All right,
To basically reserve the right to back pay should that this
I
officer.
think they want to grieve both.
I got it.
Yeah, two issues concurrently grieved.
Yeah.
yes.
No, but we'll talk
One
about it.
at
I
a
get it.
time.
Yeah.
Yeah,
Like
Two
for
issues, one at a time.
Yeah, like for the officer.
but they would put together later.
No, I don't think that's
I don't
what they're
think so
saying.
either. It's separate.
So you wanna have a hearing on somebody being placed on administrative leave with pay while they are undergoing a criminal prosecution?
Without pay.
Without pay.
You have to skip saying
Oh,
with
did
pay
I
both times.
could have swore I said without pay.
You know, again, we're just like,
While they are under criminal prosecution?
again, we just wanna make sure that it's held so we can deal with it like this case.
Yeah, the grievance can be held until the
That's
criminal
what I thought.
prosecution's
completed.
over, but we
Yeah.
just wanna reserve the right to get that back pay,
I get it.
should the
Okay.
officer be,
Found
Yes,
not
there's a
found
not
guilty.
guilty.
Yeah,
Yeah,
Yeah.
I got
Okay.
it, okay.
Okay, perfect.
because, I mean, yeah, okay.
Yeah.
And then section 7B, we accept the town's, strike of receipt of and addition of actual. And then section 8, the town included, subject to the approval of the chief of police in his sole discretion, we accept that. Article 16, we accept the strikeout of section 2.
You guys notice we're accepting a lot here, right? Just wanna make sure you know that.
Sure.
I know you're noticing it.
Chance.
I'm withdrawing the $5 syntax penalty.
Great agreement.
Alright.
Paying towards his Grammarly account over there.
Right.
Okay. And then Article 25 was the next one on my list. Section 1, the town included the last sentence, the provisions of this article shall supersede any previously existing grievance procedures, whether provided by rule, policy, or practice, we accept that. In section 2, the town included the notification by the union will specifically state that the union declined the grievance because the employee did not remember, we accept that. Section 3, the town struck, in the second and third line, have rights in the grievance procedure but shall, we accept that. And then we accept step 1, or excuse me, there were no changes in step 1, step 2, step 3, step 4. And then, if you recall, at the last meeting, we had talked about, having a process for probationary employees because the department is so small. And so we would propose to add a section 3.2, which addresses probationary employees. And the language that we propose is probationary employees shall have access to the grievance process up to and including step 3. However, if the grievance stems from a dispute between the police chief and the probationary employee, the grievance will be elevated to the town manager at step 3 instead of the police chief.
Well, the original section 3, we say shall not be entitled to grieve disappointed members. You're basically restoring the right to grieve
Yeah,
for
I just-
probationary employees, right?
For clarity, I just added a second section, but I mean, we can weave it into section 3 somehow if you don't want a different section, like a basically. That was my thought process.
We are interested in not having grievance procedures available to probationary employees.
Understood, but
Okay.
yeah, okay, so you reject my proposal,
Yes.
right? Okay.
That's a fair way of putting it.
And then I don't think there were any other changes to section 4.
Philosophically, as you understand, we want to maintain that probationary employees maintain that degree of the nature of that employment, that, you know, basically it means that they haven't reached the point where the chief is satisfied that they've met the criteria to become a full-fledged member. And we just don't want to lose that opportunity, so it's presuming that'll be a rarity since the vetting process that we're undergoing right now is such an effective one anyhow, so.
Okay. And then Article 26 is the arbitration. In Section 1, you guys added as set forth in Article 25, Section 2, we accept that. And then in Section 2, the time frame says reasonable time, we would just ask that it be defined. We propose 10 working days, but we can talk about that. And then, at the bottom of Section 2, the sentence starting with within 10 days of receipt, we would just propose 10 working days. And then the last sentence, the party who strikes first shall be determined by the toss of a coin. And then I think you guys wanted to strike that and add in filing the grievance shall strike first, so we just wanna keep the toss of a coin procedure. 'Cause
It's just more fair that way.
yeah, because essentially the person who files the grievance will never have the final strike that determines who the arbitrator is. So it's just a bit more even-handed.
Makes sense.
Yeah.
We have a special coin.
That's fine.
And it's really easy to do that over the phone.
Well, you can Google coin toss, and they have it online actually. Yeah.
Really? I never
Oh, yeah.
knew that.
Yeah.
Well, our old school people, we have no
So here we-
idea.
here we go with that old school.
We're using,
Yes,
it's like,
yes.
okay, like Gene.
We do it in West
Gene.
Palm Beach all the time. Okay. Interesting. Section.
I didn't know that.
Yeah, we do.
I didn't either.
Old school too.
Google, okay, Google coin toss, interesting.
Check that one
I will have to.
I can show you guys. if you want. Okay, so section 3 and 3.1, I don't think there were any changes that I saw. Section 3.2, the town struck prior to the date of the hearing, all the way down to proceeding, we accept that. And then we would propose adding in the language, prior to the date of the hearing or submissions of documents, the parties will attempt to agree on a statement of the issue to be resolved. If they cannot agree, the arbitrator will determine issues. And then we
I think that's
reject,
kind of presumed.
Wait, you're okay
Isn't
with that, or I'm confused, wait,
So let's add a clause before the word the parties.
okay, that
Yeah.
says,
Prior to the date of the hearing.
It
or
was just
submission
kinda
of the
more
documentation.
clarity.
okay, the parties
I
will
mean,
attempt to
it's
agree
fine,
on.
I don't
But that would have to be the case regardless anyhow. You'd have to do it ahead of time, otherwise, what's the
Yeah.
point of that clause?
Yeah.
Well, sometimes you do it the morning of it.
Yeah.
It's still before. Okay.
And then, the town added the last sentence, in such case, the arbitrator will be strictly limited to the issues and alleged violations stated in the written grievance first submitted by the union employee. I would strike that only because if an issue comes up during the grievance process,
I'm sorry, I'm not seeing that language. Where's that?
the last sentence of 3.2.
Okay. And what was your position?
Just in the event that an issue comes up during the grievance process, we would want to be able to present that and address it to the arbitrator. Okay, section 3.3, the town added the last sentence that starts with consistent and ends at shall be null and void. We reject that addition.
A little bit confused because there's a sentence prior to that begins with consistent. And it ends after the word agreement, period. That's not one long sentence.
Okay, so consistent, one, two,
With the administration.
So you wanna strike from accordingly?
are you on section 3.3?
Yeah, that's two sentences.
Well, yeah.
See the word
The
accordingly?
whole edition.
The
all
Okay,
the
both
additions.
sentences.
Yes.
Okay.
And then I don't think there are any changes to 3.4, 3.5. And then 3.6, I just had a question. The last sentence, it says the arbitrator shall not have authority to award punitive damages or relied or attorney's fees or costs. I'm not familiar with relied. Was that maybe a typo or?
Well, it's meant to
Okay.
be, or rely on. Is that what it's meant to read,
Typo?
Denise?
No, I think that's a typo.
Yeah.
So should we rely on?
No, it should be punitive damages or attorney's fees.
Okay. So if we just strike that or relied, we're fine with that, the addition. And then you guys, down in 3.8, you wanted to add subject only to review under applicable law. We're okay with that. And then 3.9, you struck that. We're okay with that. And then 4.0 becomes 3.9 in that case. And then section 4, it was 4.1, but it would now be 4.0. We accept the strike through that you guys proposed, and I think, sorry, it's just kind of hard for me to read. FOP shall have the right to compensate its witnesses from the time pool, and 1, you struck that, we're okay with that. And then Article 30 is what I have next. Section 1, you guys struck the middle of the paragraph, provided, however, that said formulation, amendment, revision, implication will be neither arbitrary nor capricious. We accept that. And then you guys struck at least. We accept that. Section 2, you guys proposed this language, we accept that. And then section 3, you guys added in any town or department rules, regulations, policies, or procedures, we accept that. And then we accept the strikers of the and pool. And then you guys struck through section 3, which I think was supposed to be section 4, typo, but we reject that strike through. We would like to keep this language. And then depending on, how you guys feel about that, we would propose changing the time frame. So we would propose maybe 30 working days instead of 10. And that's all I have.
You had one more 32. Do you want to?
We'll hold it for a second. Yeah.
Okay.
Do you have any new proposals to make this morning?
No, we haven't.
So just
See if we
to
can clean these up and then bring it.
understand, you guys said you would bring forward a new wage proposal. You don't have that
No,
today.
not yet.
Can I ask you a question as it relates to that? When do you anticipate doing, we gotta get the contract over with.
Mhm.
So when, how soon will you be able to do that?
As soon as you agree to everything.
In other words, you wanna set everything else aside, get it done and then focus on the wage proposal, is that what you're saying?
Yeah, we'll get some wages to the next time we meet. Yeah.
Okay, okay.
Yeah, no problem.
I'm-
I wanna get it done
The
too.
commission
quick.
members are saying,
Yeah.
hey, when's this contract coming
Yeah,
back?
yeah.
And,
Well, I think once we get all this taken care of, we should be able to get right to it.
okay,
Yep.
all right, fair enough.
You good with that?
Yeah.
Okay. You guys wanna take a recess, to take a look at all that, and then we can try to TA a lot of these and,
Let's recess.
okay.
Okay.
You want us to stay?
Okay.
There's a, Sergeant Dodge, you know how to go through that room and then there's another little room with tables in
Yeah.
it?
Okay, we'll go in there.
Yeah,
Perfect.
Do you want us to wait until they get it shut off?
yeah. Oh, no,
No,
you
no,
can,
no.
yeah, I guess, yeah.
It's now 10:27.
Okay.
Stop in my recording.
Okay.
Just start unplugging things, see what happens.
So just, give me a text when you're ready and
Yes,
I'm right back.
thank you.
Thank you.
Am I good to leave my bag here?
Okay.
You got it.
She's on her way. Stand by.
You know the code?
Is it locked?
Can you get them through, Chandler?
I didn't know locked either. Somebody for emergency.
I think he's coming around the other way.
Okay, thank you.
Let Chandler come around. Tell us when it's a green light, Suze.
I know you, I know you're gonna address the stuff we just talked about.
Okay, you're good.
I'm on.
Okay.
I know we're gonna talk.
All right, we've
about-
reconvened the bargaining session with the FOP between the municipality and the new FOP unit here in Pembroke Park. And both parties have had an opportunity to caucus. And after presentation of proposals by council for the FOP, Denise, on behalf of the municipality, is gonna make a few remarks.
Okay,
Or
so
Lorena, I didn't know, I did this wrong before, so.
you can handle our new
Yeah.
stuff, I'll do this.
Did you mean to say something, Paul, just now?
Yeah, when we skipped Article 7 and 12, we will come back to that. We do have the,
Okay, so why don't we hear you on that?
you wanna do 7 and
Yeah,
12 first?
and 32?
Sure.
How about 32?
You have 30, I don't have 30.
No, I don't have 32. No.
You did that last time.
Okay.
I think I had it under skip, you guys skipped it last time,
Okay,
so I don't think you guys
I'll
provided
have
us.
to,
Okay, well, we can move that to our proposals. Okay,
I was also have to say.
I just don't have copies.
we can go make copies.
Okay,
'Cause this is ours, right?
That's ours.
Yeah, okay.
you can correct my missing. Yeah, we'll do 7. Alright. So, Brian, if you wanna address 7 real quick, we do the 240 hours, we're,
Yeah, under Article 7, Section 1, 1D, I think the only changes we had kind of talked about was changing the hours from 120 to 240.
So that the attendance at meetings concept.
Yes, exactly what we talked about last time. And then clean up the grammatical error, syntax error. You're going,
Okay, thanks.
Of where?
From 100, I'm sorry, Section 1,
D,
Ds,
okay.
from 80.
from 120 to 240. That would be the only
Okay.
change for that. And then
80 to
underneath where it says 100, it actually says 80 as a numerical.
Right.
We're just changing that to 100 numerical because it's a. That would be the only change from that part.
On that issue, we wanna talk about, we're not ready to TA that
Okay.
right
Okay.
yet, just so you know.
And then you have the language under.
Yeah, can I see that?
Can I have a question before you
Oh,
move
sure,
on from
sure.
Article 7? So, all the other strikeout and underlines you're okay with,
Yeah, I mean, yes, we would be okay with that, but like you said.
but
we
you
just-
wanna change
change
the
the
120 to
hours.
240, okay.
But, if you, still on Article 7, if you go to, Section 2I, which is the last page, we
Yeah.
had, if you recall, we had discussed like a presentation FOP might be able to make to the new hires, and so I just have some language, so it would say, solicitation of any and all kinds by the FOP, strike, including the solicitation of membership, and the collection of FOP monies shall not be engaged in during working hours in town facilities or using town channels of communications, except that the FOP may present membership information to new hires during the orientation process. And, it would just be limited to that.
Okay, so we'll have to take a look at 7, okay. And then, what, 12?
Yeah, the subcontracting, Article 12, we'd be okay with it as long as you add Section 3 back in there. You got offices that are vested and invested in this place, and we feel that needs to be in there to protect them.
Okay, so here's where we are. We can TA 1, 3, 11, and 16.
TA1, TA3, and is that 16?
Correct. And so we'll send those to you separately by email after today. Yeah, 1, 3, 11, and 16.
11 and 16.
Yeah, I'm sorry.
Cool.
And then, as to your counter proposals, on
Which one
article,
are we on?
Which one?
on, I'm gonna list them, on articles, Article 7, 10, 12, 15, 25, 26, and 30, we are going to look at those and do some work on them, okay? And then Lorena's gonna go through the rest of our stuff for today, including our Article 32.
Exactly.
Go ahead, Lorena.
Yeah, so we can also agree to your proposed Article 21, which was jury duty. We can agree to it as,
Do that one?
yep,
Okay. Sorry, one more time, 21.
21.
Okay.
The town is going to reject, as proposed, Articles 4 and 14, which we believe deal with the same subject matter, but we're rejecting both. And we are rejecting Article 29 and 31.
Let's go over them please again.
Sure.
Article 4.
Article 4,
Mhm.
14,
Mhm.
29,
Mhm.
31.
And so that was legal disputes.
Now, we have about 13 other proposals or counter proposals in response to the unit. Let's start with Article 3. That's for them.
Article 3.
Up to 13, I'm sorry. Article 13, the vehicle assignment.
You guys have those back there?
Yeah, we are.
Anybody need one? No.
So understanding that the pay scale, gents, is actually superior to the IRS payment scale. So this is actually an increase for the membership, I think. Saying that right, Jason?
It's currently what they have right now.
Yeah.
Yeah.
It's the current
This
policy.
is currently the
Yeah.
current.
Yes.
It's
The
actually,
reimbursement
it's higher than what you
schedule is-
proposed.
It's higher, yeah.
Mm-hmm.
It's the current,
It's actually what's in existence.
No, but I mean higher than the IRS.
They didn't
Lower than
propose
the
that.
IRS
Yeah.
in terms of mileage
And I'm
back
getting,
Oh,
and I'm
okay.
getting,
each day.
and I'm getting deducted way too much out of my checks. I don't know what that from at all.
You moved, I don't, you have to let them know where you.
I didn't, I'm sorry, I'll talk about it later, but it's not.
Okay.
It's not lining up to what,
We have our proposal for the pay.
This is a better deal.
What did you propose for pay, no pay?
Yes, I
Your
thought-
proposal
what
was
you said?
just to incorporate the
Okay.
policy and not make
Yeah.
any changes. We believe that this is consistent with the current policy. It's the same schedule and under the same conditions. You're limited to the Tri-County area. You're gonna be deducted every pay period, the amount based upon distance from your duty station to your house. and you'll have to sign that user agreement, which you've signed anyway, already. Can I go to the next one?
Want to move on, or you have any issues?
We can hold it.
You can hold it.
Yeah,
We'll talk
just
this.
a couple.
Yeah, we'll talk about it.
We come back another day.
The next article is Article 18. So we generally agreed with the union's proposal,
Okay.
with, some exceptions, and that is, there's such a thing as being held over, or there's a window of time where you may have to report. We, identified it as an hour before your start or end of shift, so if you have to report to court within that hour, you're not gonna get, premium pay, you're gonna get regular, straight time,
Straight time?
straight.
Well, unless you work more than whatever the
Right.
overtime is, but
So,
So for example, look at section 1, which is court time, right? Section B is what you propose, it's just been reorganized, right?
Okay.
And then section 1, you proposed the regular rate of pay if they're scheduled to work during their shift, during their normal hours. We're expanding that to 1 hour from the start or end time of your scheduled work hour. You'll get regular pay. So that's your proposal. We're just expanding your shift or that pay to be, to include 1 hour before or after the start or end of your shift.
so if I get called at 6 o'clock in the morning after I've been working all night, you're saying that I get like straight time?
You would get, but this is, you would be testifying during regular scheduled work hours. If your shift ends at 6:30 in the morning,
Okay,
you're
so
not,
you're-
court
oh,
is
so
not
it's
in
not-
session.
So you're saying that it's during the regular scheduled hours that I get called to testify?
That's right.
Straight,
If you've
yeah,
got to
I
report to
understand.
court during
I
your
thought you were
regular
saying that
hours.
if we're
No,
off,
you're gonna get time and a half for
I
that,
just wanna make sure I
yeah,
understand.
no, this is,
unless
yeah,
there's night court during your,
yeah, no,
You're-
no night court, so.
Just trying to explain that to someone.
Yeah.
okay.
It's a good show.
All right, section 2, we understand that this may be unrelated to the town's duties. We agree with your, proposal, and you can use, the only change is you can use your paid leave, and we really don't need any, documentation as you propose in B or C. It's an administrative burden for us, and you'll need to report if subpoenaed, it's on your own time. The town doesn't really have anything to do with it.
Strike C.
Now, you have that concept of standby, you've not reported to court, you're under subpoena to, testify as a witness. For the day, you have a maximum of 8 hours, and we propose, that you're gonna get paid 1 hour of straight time or 2 hours at halftime, unless you have to report under section A. So we understand that
Right.
standby and court time are two separate
Correct.
sets of supplements.
So if they put us on standby for 2 weeks, which is what they generally do, what are we seeing here? I'm a little confused with this.
Well, so I think if what you're referring to is a subpoena to appear for a trial,
something.
right?
What Broward County does is they put us on standby for 2 weeks. So essentially what it means is that if we're on standby, we have to be available to respond when they call us to come in and testify over a 2-week period for that one case. And I can tell you that I'm on standby for 4 or 5 cases at a time
Okay.
sometimes, but are you saying that we would only get,
So what was your proposal? What were you guys asking for? You were asking that for that entire 2-week period.
well, it would be an hour a day of straight time. Is what Paul means.
The straight time hourly rate for each hour on standby up to a maximum of 8 hours of standby duty in any one day.
One second, I'm sorry, let me pull up what we have. How did we have that
Well, this is,
before?
this is what we proposed.
Yeah. Right, no, I wanna make sure that, I might be just
Look at this
not
again.
explaining it
Yeah.
the right way.
And we can always come back to it.
Yeah.
Yeah, because if you're on standby for 2 weeks, we understand if you're subpoenaed to appear on a particular day and you're just waiting around because
Yeah.
you've got to report to court on that particular day. But if that's not the way the process it works, then I think we probably want
yeah.
to look at some limits on that because the concept is not to pay you over those 2 weeks times over that
Just
2
because
weeks.
It would be
Yeah.
1
Just
hour a
because-
day, but you understand that we're not eligible to go anywhere, we have to remain.
They're
well,
confined
we can't,
to
we're
Broward.
confined to Broward County,
Yeah.
I can't go out of town on my day off if I'm scheduled to be on standby for subpoena, so we're not getting any compensation to have to stay around Broward County and not be able to go anywhere.
So it is two different concepts because you're referring to someone who may be off duty, but if someone is on duty, you've reported to work, you just know that at any moment your job will be interrupted and
Right,
you've
it
got to
would be only
report.
for the people that are off duty
Okay.
during the time that they're on standby, so if I'm on standby for a 2-week period, essentially 5 of those 10 days we would be on duty, it wouldn't really affect the day shift people, the night shift people were
Right.
off.
So you guys don't deal with the prosecutors and say, hey, listen, I'm not gonna be here on Friday because I'm going up to Orlando with my
Well,
family.
if we have a predetermined vacation, of course we could put in for
Okay.
vacation time. However,
don't, right.
if we don't have a predetermined vacation and they subpoena us for standby for 2 weeks,
Draw on the woman then.
now I can't even plan a vacation or go anywhere.
I mean, cause I've subpoenaed people before and I know I work with my witnesses in terms of
The problem with
the timing and stuff. And,
Yeah.
and when they're gonna be here, when they're not gonna be here.
the problem with their position and just my experience as a prosecutor in Miami-Dade, those prosecutors are at the will of the judge.
Oh,
And-
definitely,
yeah.
there always are.
Right, and then a judge can say, no, your witness has to be here tomorrow. So these witnesses don't really have any pull on when a court case is gonna go, when a trial
And they
is
never
over.
file anything with the court saying, hey, I'm out of
Sorry.
town? Yeah?
Whereas I worked in Miami-Dade, so you call your officer the day before, hey, you're on standby for tomorrow, and you put that officer on standby for 6 hours.
Right,
That'd
Not
be
for
fair if
2
that's how they do
weeks.
it.
if,
You
yeah, if that's how it's
bankrupt.
done.
An entire organization that way, I'm sorry.
Well,
I don't have any other place in Broward that does anything like
yeah.
this.
did we not still have it in Fort Lauderdale?
So you will be on standby for 2 weeks.
Oh, you might have, I don't do Fort Lauderdale, it might be in Fort Lauderdale,
So-
but all the other places, I'll look
No.
into it. And I think we need to spend more time,
Yeah.
make sure we understand what it is that you're talking
Understand
about on this, cause like an hour a day for 2 weeks, that's,
That's, yeah.
and then actually the language, it talks about an hour a day, but up to a maximum of 8 hours, so.
Well, it would be a total of 8 hours, not in a day, not per day.
No, for the whole thing.
So, but it wouldn't,
Okay,
yeah.
we got it, we'll look at that,
Right.
okay,
So then actually we'll collect Article
Yeah.
18 back.
yeah.
We'll hold
Yeah.
off
We
on
will
Article
look at 13 again,
We have to revisit that.
We'll
18.
revisit 18
I
again.
think we need to,
yes,
contact the judges and the prosecutors, that's the that's
not
where the
really
problem
the
is.
state's part.
yeah,
Put anybody on standby for 2 weeks, they're to get dockets every day, you know
Yeah.
what's
For
going that
25
day.
years, it's been
They
happening
should know.
that way. Broward County's been doing that for 25 years.
They, yeah, they,
News to me.
That's
I haven't
that's
been here
crazy.
20, but I must have missed 5.
Go on.
I'm letting you know,
worked
Chief,
on
how,
Cox cases all the
I'm
time.
letting you know how it's been done in Broward County for 25 years. I mean,
Broward is very trial heavy
yeah.
compared to Connecticut, as far as I know.
All right, so we'll revisit our response to 18. We're moving on to 19, bereavement. So I think the town actually, is proposing a greater benefit, than the union's original proposal. It's expanding the relationships, under section 2. And then as to the time allowed, they're proposing 3 workdays if the funeral is of paid time off, if the funeral is in state, and 5 workdays if the funeral is out of state. And of course, in section 3, we may require proof.
That's fine. The only reason we put that in here was because the town policy says 3 workdays, or 24 hours, and we don't work an 8-hour day. So that's the only reason we had changed the language from the town policy. It doesn't really kind of line up to what our schedule is. So 3 days would be fine if it was under a 12-hour day. That's what was kind of what we were.
Then that's what we put in.
So I
3
think
work days, that's our
workdays.
change, yeah.
And the unit of measurement, I think, also accommodates the different shifts in the department, right? So if you have someone on admin, they work an 8-hour day, it's 3 work days for the person,
Understand?
so.
Yeah, yeah.
Well, thank you. Yeah. Clear that one.
Okay.
Okay.
The next article is Article 20, military leave. And this was your proposal. We are willing to incorporate this benefit under the state law to the extent provided in state law. So I think that the law has a maximum of 240 working hours, and we're willing to provide that because it's required of us to do so. But the extra benefit we are striking, so that would
Which
be
is what?
the extra maximum of 10 additional days.
So whatever we're required to do by Florida law, we'll do.
Yeah, yeah.
Yes. Okay. What was that?
You agree to
TA,
that?
yeah.
Okay. The next is Article 23, holidays. Here, the town also proposes an increase from what you originally proposed. And that's because the town observes Columbus Day, so we've added that. We agree with the concept that, all the members receive 8 hours regardless of their shift. And so the math up in section 1 is the number of listed days times 8 equals 96. Now, if you're not on duty, you're gonna get 8 hours of time banked. If you are on duty, you can see in section 2, you will bank the 8 hours of time, and you will get paid your initial 8 hours if you're on that 12-hour shift, right? So you're actually getting 2 times, the time that's banked plus your regular pay for working. And then the town proposes to pay you the balance if you're on shift work for time and a half. With respect, you had originally identified holidays declared by the town manager. Well, those are not defined, and that's the discretion and largesse of the manager. And if that is the case, then you'll see at the end, the new section 4 is you'll also receive 8 hours, but you have to use it or lose it within a 12-month period. It actually, we also propose to section 1A to, we propose that employees who separate from employment on the eve of a holiday will not receive the holiday pay.
Can we hold this? Can we hold this?
I
Take
will
a
hold
look at
down.
that one, please.
Sure. Next article is 27, off-duty employment. So this is the town's response to your initial proposal, which was, let's keep the current policy, but the current policy really doesn't address any benefit to the members. And so this is our response. We'll create the policy, we'll fairly distribute the assignments, and the chief retains discretion in determining whether a member can perform outside employment or not, an off-duty job or not.
They would just put a request in to work a detail and the chief would approve it or not.
I think it's gonna be part of the policy that the department crafts in creating an off-duty program, right?
I don't know of any police department where the chief doesn't have that kind of authority. So,
No, I'm okay with it, because it's pretty much the same as everywhere else.
What do you think?
So.
we'll TA that and move on to
No, I just had a
36.
question, we struck, section 7 was struck.
Section 5? Oh, I think you're fine.
Sorry, 7, if it's non-police related employment, where would that be addressed?
Well, there, usually you have, ethics requirements, right, that what you're referring to is a second job outside your
Right.
town, which is not related to policing off-duty jobs.
Right.
Well, you need to follow the ethics, laws in place, whether it's a county ethics code or a state code. And the town, you would need to follow the town's policies with respect to reporting that second employment so that it's vetted for purposes of conflicts and.
So if I have a business cutting lawns, I go to the chief and tell him I do that on my, I have a second job. There's no issue with that.
There should be no issue as long as you follow whatever reporting
Yeah, there's reporting
requirements and
guidelines.
I
approval.
guess that's what I was asking, is that going to be listed, is that gonna be under our or city, department policy for that? Are we talking about, that would be listed under department policy?
Let me ask a question. Does the town have a policy about second employment?
I think, no, I think the handbook says as long as it's not in conflict with
Okay.
their current employment. So the lawn care guy, the way I read this, I don't even think you have to talk to the chief about it.
Every
Well,
place I've
there's-
worked, if
yeah.
you have outside employment, you have to get it
Yeah.
approved. And I think that would
Yeah.
be,
Well, it says regarding all off-duty police employment.
So there's off-duty details typically,
Right.
right? And this, however they wrote it, that's how they wrote it. This was non-police related employment. So he's right. Typically, you have a rule about a second job, and that you have to get it approved. You have to make sure that it. I think there might even be a state form you have to file, I don't,
It's not a.
Well, it's
it's not a
not,
state, it's mostly cities.
it's, in Dade County, it's
Okay.
the county's ethics
Yes.
code. And so what you would be required to do
We
is
have it up here.
not you have you have a very strict Broward County ethics. I think that's something maybe. you
Okay,
can
we'll look
and
at it.
Advise the town on.
Where
But
does,
indeed,
where does this say that if it's not police related, you have to go to the chief? Where does it say
So
that?
if you're gonna do security
no,
work,
that's what
right?
we're,
So
that's what
private
we're
security
saying.
work, you're gonna, celebrities coming into town and, hey, I wanna hire Sergeant Dodge to do private
But that's
security.
police related.
That would have to get approved through the chief, you have to have
Right,
a private chief
but-
I'm just saying where it would be written that it would, the non-police related stuff, the off-duty
We're
employees.
gonna create a policy for secondary
fall under
employment
the-
involving that, but that falls under
It'll
the
fall under
ethics and
Right, so
professional.
it'll go under our department policy where we would.
That's
have
gonna fall under our
that would-
policies.
That would
Correct,
align
yeah.
with the ethics.
That will
stuff, so we
fall
can-
under the
okay.
rules and
Yeah.
regulations according to our policies.
So in Dade County, you not only have an obligation to seek prior approval before you have a second business or a second job outside your public employment, but you also have on a yearly basis to report your income from your second employment. That applies generally to most public employees as determined in the ethics code for Dade County, so.
Right, and I'm sure Broward probably has the same, I was just looking
And
for
that's
the
what we'll
the
look at.
language to see if it would just fall under our department policy for that, since it was stricken from.
So are you TA in 27?
No, I was just asking. for
You want to come back to
clarification.
it? Is that what you're saying in
No, I was just
27?
asking for clarification on that.
So are you TA 27 or are we
Sorry.
coming back to it?
I'm okay with the TA.
Okay.
The next article is Article 32.
There's highlights on it. That's-
Yeah.
I have 32
Oh,
here.
32, yes, because
There
32
was a
was what
question
we,
whether we addressed it at the last meeting or not.
Oh, okay.
so on the
Yes,
top.
and
here.
that's at the top, it
me
reads
do
1029, it should reflect today's date 11/21.
It wasn't in what you sent me yesterday, so
It wasn't, we
wasn't.
expected them to have a counter
do they
proposal,
have
but
one?
it maybe did
We've
not.
given
Yeah,
them
they have a copy.
okay.
11,
I've given them one.
You got one? Okay.
Okay, so personnel records.
Yeah, and so we believe that it's the prerogative of the town to determine how to keep and where to keep its records. You certainly, we do recognize you have a right to access them, and we provided for that in there. We also agreed to, your proposed section 4, the new section 4, which is that written reprimands are, to the extent possible under public records law, not considered as part of the disciplinary record of the employee after 2 years.
Now we gotta go back to the other,
Yeah, so then we have to,
change that.
we can talk.
Hmm?
We have to follow about a written reprimand discipline or not, that's what.
Well, that was your proposal
Yeah,
today,
yeah,
but
yeah,
I
yeah.
understand
Used
that.
word.
We're both discussing
So this is our
Article 15 and
proposal, obviously.
our counter to
It was
theirs.
our counter.
Right.
To theirs.
You see where you have the strikeout in section 2,
Yes,
which appear in the employee's official blank. Official what? You got a strikeout after the word official. What word comes after the word official?
Official personnel file.
official file, it should be
Oh,
official.
official file.
Personnel,
Personnel
official
file.
personnel
Because
file.
it's right here, it reads official nothing.
Personnel file.
No, the insurance file, they were fine. Maintain official.
You wanna come back to this then?
Yeah, we'll just hold it if you don't mind. I'm sure it won't be.
Yeah.
Okay.
Next article is leave. There is a slight adjustment to reflect the current, policy for, all town employees, and so those, ratios are what is currently provided to all employees.
I just want to point out that I know there was an issue about financial constraints, So some of the things we were trying to do is put a little bit more benefit on stuff that wasn't as taxing from a financial standpoint, and it would help bring other people with experience here, and this was one of those articles that we were always trying to do that for, by increasing it slightly. I don't know if that was considered, and it was everything was struck through, but
So you're saying to attract people, there should have been
Just
4,
another-
6, 4, 6, and 8?
it's just another benefit that we're trying to utilize to help
Yeah.
attract new people to come here that, might have guys coming here with experience and pensions, and this is the kind of thing that is really going to help bring people in, health insurance, these types of benefits, like vacation accrual.
Yeah.
It's a tough job and guys want to take time off. We're just trying to add a little bit more benefit for something that we talk about being a tough job. That's all. It was just something that, that's why I kind of increased it.
You guys wanna have James look at that?
Yeah, let's have James look at that.
Okay,
Yeah, so-
just so I can clarify, under our proposal, it says 4 and then it says 3. The 4 is not struck out. Was that meant to be struck out?
It
It
is,
It
but
is.
it's indistinguishable
Oh.
because it.
It's the number before the way.
Yeah,
Yeah.
the way the
Crosses
font
before.
I assumed
has
it
the
was struck out
crossbar.
anyway.
So it should be 3, 5, and 6
Yes,
as opposed to 4, 6, and 8.
Your proposal, yeah.
But we're gonna have James look at that.
do you wanna
Oh.
This back.
re-propose?
Yeah,
We'll re-propose then.
Oh, you want it?
Well,
You want that
yeah, we
back?
could leave it for now, and, but we'll take a look at it.
So it's our proposal for now, but it's open for discussion.
I mean, would 4 hours make so much of a recruitment difference?
overall, I think giving guys extra time off, I mean, what does that end up being? 3 pay periods a year with an extra hour?
26.
26.
You're talking 4 hours.
What's that?
I understand your point.
Yeah,
I'm
it's
just
an extra
trying to,
day.
we
Yeah,
don't-
it makes a
good
difference. It would make a
officers.
difference to me for sure. Guys want to take time off, and your charge especially. This kind
When
of
they're having
job.
trouble taking time off.
Yeah. I mean, we're working. Guys are tapped out with hours right now, working so much to try and keep everything afloat. It's just one of the things that everybody.
Let's have James look at it. to
Yeah, no, that's
see-
all I asked
see what
for,
the
Yeah.
impact
for
is.
consideration on
We're
it,
gonna review it.
because this is just one of the things that's
Yeah.
really important about it.
So it's 40 hours,
Okay,
yeah, so.
Our next proposal is sick leave, Article 34, our counter to the proposal. And I think we may reach agreement on this one, given that the only thing that changed is the math, right? So we're saying a maximum of 104 hours each day based on the 4-hour accrual that you proposed.
you guys wanna take that back and look at it? Yeah.
The town also has new proposals. And we're gonna continue to number them. That was the end of the union's proposal package, right? 34 articles. We've now gone over each one of the 34 articles. So what the town, did is continue to numerically add proposals at the end, so we're starting on 35, but we understand that
Yeah,
the
well-
numbers may be reshuffled once we,
Combine.
yeah. So Article 35 speaks to probation.
Right, have they seen this prior to today?
No.
No.
Okay.
Yeah.
This is new, I don't expect you to TA this right now, so you wanna just review that in your leisure.
It goes back to the probationary issue we were talking
Right.
about before, so it's up to you.
Yeah.
But yeah, maybe
Can-
if you wanna
Yeah.
circle back.
And
Yeah.
this only speaks to new hire probation. The town will present a probation article for promotion, just not at this time. Article 36, health insurance. Whatever the term of the contract, the town wants to reserve the right to, change, the insurance plan, only because that's dictated by the marketplace and it's dictated by experience and it's dictated by, the costs and the town's ability to pay for insurance as a group for all its employees. And we understand that that's the status quo today anyway, but we want to expressly recognize that we want to preserve that ability.
And we'll provide the employees with the same thing we provide our other employees.
It would just be same across the board. for
Yeah.
employees.
Well, it's
Yeah.
one group, right?
Yeah,
Right,
one
yeah.
group health insurance, so everybody will get the
In
same.
fact, I don't think that health insurance company will allow us to have different categories of coverage. They just won't let us.
I'm okay with that. That's I'll TA.
Just two more articles, and these probably would concern Rose. They're just,
Thank you.
the savings clause and the integration clause. And, I'll give you both at the same time, Article 39 and Article 40.
Savings clause, first proposal?
No,
We did not,
no, this is all new language.
but that wasn't one of them that was in there.
Both of these are standard boilerplate in every single agreement in the country.
Can we hold these? just
Sure.
so I can-
Yeah,
Absolutely.
I'm
And that's
sure
all
there
we
won't
have
be
for
an
you
issue.
today.
Okay. Let's give us 10 more minutes? Or do you wanna?
Yeah, to caucus?
Yeah.
Well, or, I mean, you think of coming back with some responses? Because if not, we should
Yeah,
just
I-
adjourn.
Yeah, we might be able to close a couple more.
Okay, good.
So let's get to 10 minutes, we'll come back and then we'll
Okay,
break for
no.
the day and we'll set some more dates.
Before we just break, can I go over the list of articles that we TA'd
Oh,
so you can verify that?
Do all my paperwork, it's gonna be tough.
You can just write them and then you can
You got it,
review
right?
that when you caucus.
Alright.
So far, we've TA'd the preamble, Article 1, Article 2, Article 3, Article 5, Article 6, Article 8, Article 9, Article 11, Article 16, Article 19, Article 20, and Article 27, and the last one was health insurance.
21, I
Which are
think
21.
also.
I have 21.
20, 21, 27, and 36.
That's what we just went over today,
Yeah.
right? 19, 20, 21. 37.
Yep.
And 36.
And
That was the
then,
health insurance
Yeah,
one?
That was the health insurance.
Do you mind going back to the first
Sure.
three, please? Start from the beginning.
The preamble,
Yeah,
Article 1,
Yeah.
Article 2,
Right.
Article 3, Article 5, Article 6.
got it, yep. That's what I needed.
and then for my clarity, you guys rejected 4, 14, 29, and 31.
That's correct.
Is there, the ability of you to, I don't know, the collective bargaining rules, if we're allowed to do this, have you send an email to everybody that that's your understanding, and then get an email back from Rose, so that, as opposed to us just verbally saying what those are, that we have that, sort of in writing. And I want to say one other thing as relates to that. It's my understanding, as I've talked to you about this before, that as we move forward, this is not a speak now or forever hold your peace kind of situation. So
Yeah.
if there needs to be some other horse trading, nobody's bound. But if I could see something in writing that maybe goes from you to Rose and then Rose back to you, and then we
yeah,
could circulate it to everybody so that we
I
know
would
that.
feel more comfortable next time just coming in with saying, here's a summary of where we are.
So you
Next
don't
time we have
want,
a bargaining
so
session.
you're saying we should not have an email exchange that says what we've done so far?
Well, I am going to send an email out with the, agreements that we have on the TAs for
Yeah,
today.
that's what I'm
and say,
talking
here
about.
you go, sign this. But if you want a summary of everything,
No.
like, okay, on the TAs, yeah, we're gonna do that, cause we said we're gonna get them to them after
Okay,
this, so they
okay.
can sign that. Yeah, that's fine.
We haven't sent you those articles that we TA'd the Word file, I mean. We'd be happy to.
It doesn't
Send
have
them
to
and then
do a
bring them
PDF, we can
Yeah.
do whatever,
Yeah.
Something we could just add to
Yeah.
it and
Yeah,
everything as you go.
exactly. exactly.
So,
Alright, you wanna give us 10?
Yeah, can we
Sure.
just get 10 minutes?
yeah, 11:45.
As soon as you let us know when we're off stream,